Now, Accra High Court has ordered the National Communications Authority to provide a list of all FM radio stations indicating the name of a company, the name of a radio station, the location and the frequency number that he had shut down by the Media Foundation West Africa. Followed the authority's 2017 FM spectrum audit carried out. The court in its decision also asked the Media Foundation to pay an amount of 1,500 cedis before the information is provided. The court, presided over by Gifty Ejayado, admitted Parliament has not approved any statutory fee for information, but the MFWA should pay some 1,500 cedis for the information it's ordered the NCA to furnish it with. We remember that on July 22, 2020, the Media Foundation for West Africa, through its executive director, Suleiman Abrahama, submitted to the NCA in its access to or request for information to provide for it a list of all the FM stations is shut down in its cleanup of a sector sometime in 2019. Let's listen to Muhib Saeed. He is a senior programs officer in charge of freedom of expression at the Media Foundation for West Africa, reacting to the court's decision a short time ago.
We have to get back to the office and get the advice of our lawyers and then decide what the next line of action will be. But we are excited that we've been able to test the law and been able to get the court to pronounce that we have the right to demand the information that we demanded on behalf of the public.
So you heard the Muhib Saeed, Senior Programs Officer in charge of freedom of expression at the Media Foundation for West Africa. He joins me on the phone for a lot more conversation on this. Thank you for joining us, Muhib. You have stated that you take this with mixed reactions. Exactly what do you mean by this?
Well, in the first place, we welcome the decision by the court, which directs the NCA to provide us with information that we requested, to the extent that the amount demanded by the NCA to us was a ploy to delay or to avoid giving the information. We think that this decision is positive, but we are disappointed regarding the amount of money we are being asked to pay to access the information. As you rightly said, the judge recognized that the RTI law, the subsidiary legislation that is supposed to set the amount of money that should be paid as fees for access to information, have not yet been fixed. And yet, within the same RTI law, the provision is that the fees to be paid should cover the cost of reproducing the information. Now, the NCA has carried out an exercise, and that exercise must clearly be based on information that is available to it. We are not going to trigger any new processes within the NCA to be able to get information. It is information that is already available and based on which it had carried out an exercise to shut down radio stations that are supposed not to be in good standing. So clearly, the fee was to cover reproducing that information. And we think that 1,500 for reproducing an information, either on a flash drive, either by printing or photocopying, is on the high side.
Now, tell us about some of the reliefs that you sought that were not granted by the court. For example, I know that you were demanding that the NCA, for example, makes available certain portions of a 2020 audit report it posted on its website that were taken out, allegedly. On that score as well, how does the MFWA receive those?
Well, that was a request for the NCA to explain the reason they changed some information on their website. This information contained the dates of first authorization and the date of last authorization for all authorized broadcasting stations. Then later, a second one was placed on the site which took away the date of first authorization and the date of last authorization, which is what actually shows that a radio station is in good standing or not in good standing, because we can clearly see when the last time was that this radio station renewed its authorization. And we thought that it was very critical to ensuring transparency in the exercise that the NCA did. Unfortunately, the court, in its wisdom, decided that the NCA is not obliged to explain why they did that.
Now, before I let you go, Muhib, I want you to tell us how soon should we expect you to action this latest court ruling by way of making processes available to go through to the NCA, pay that amount of money and get the information you need?
We've not yet decided whether we're going to pay that money. 2,000 Ghana cedis really for an institution might not be too much, but we are demanding information on behalf of the public.
Right.
The RTI law is not to serve the media or certain institutions. It is to serve the public. Individual Ghanaians who need certain information on certain public interest issues have the right to demand these informations under the RTI law. And if a precedent is set which makes the fees quite exorbitant, it would not inure to the promotion of the rights of Ghanaians under the RTI law.
Thank you very much, Muhib Saeed. He is the Senior Programs Officer in charge of Freedom of Expression at the Media Foundation for East Africa.